All right, in this short video, I just want to break down what it looks like to read a document in a tax foreclosure. This one happens to be in Cherokee County, Georgia, as you can see at the top, Cherokee County, and it was in the Superior Court. So that tells you where Cherokee County files their tax deeds information and foreclosures. So at the top of here, you see the official capacity, which is the tax commissioner. That's the one who started the foreclosure. That's also a definition of what a petitioner is. The petitioner is the one who starts the foreclosure action. In a mortgage foreclosure, that would typically be the lender. And then maybe the lender's attorney would be in that same section of the document. And then down below, these are going to be the respondents, or a lot of times you'll see that's going to be the defendants. All right, the defendants will be the previous owners. And if you see this kind of wording, and or his or her heirs, a lot of times that does mean an estate, but that's also can be a default wording that the petitioner wants to make sure that they're covering all their grounds. So they are quite sure, because Mary Randazzo was the person in the case, but then they're also defaulting to anybody else. All right, and you want to look in here to see the names. Now, in this case, then you're going to read the petitioner's petition. Okay, so what that means is the tax commissioner in this case is actually giving the surplus to the court. Okay, they're making the deposit into the court. This was actually a consent order. This was the actual end of the docket, and you'll see why here in a moment. But as you can see here, number one is the first section here. The tax commissioner still retains excess funds in the amount of, as you can see here. And then it just explains the excess funds arising from the tax sale September 5th, 2023. And then the address. So if you want to stop right there, even though it says not an authorized copy, that's just the default thing, meaning you may edit this and they're just saying, hey, this is not authorized, but this is the information that they brought. Most court systems don't put that on there, but I've seen it quite often, and that's just a security measure. But if you were talking to a claimant and this is what you wanted to send, it says right there, how can I, if they had a question, how could I owe, or how could I have money left over when they sold the property? This says it right here, and it's only 3 sentences, right? And that's coming from straight from the court. So it says right here, the date of the sale, the address, and it also gives you what we covered the other day, which was the parcel number, tax assessor's parcel number to that property. All right. And then down below, section 2, they have to serve notice. All respondents have been properly served, meaning notified, mailed, not necessarily called. That's where we come in, because a lot of times they're mailing this notice, to the previous address, and they probably have moved because the property got sold, especially from September. This civil proceeding, this consent order was from August 23rd. So what they're doing is, they're covering their grounds. Hey, I'm serving the notice to let them know what's going on, and it's given sufficient time. They're letting them know that, just giving them time to make that claim. All right. So moving forward, now you're going to read in step number 3, or section number 3, item number 3, respondent, which we learned above. The respondent is one of the defendants and the person who should be eligible to claim. The respondent, Mary Randazzo, makes a claim to the excess funds by virtue of her ownership, meaning she's making a claim to her ownership. That doesn't mean all of it, unless her ownership was all of it. Maybe she was the single owner in that case. All right. And then down below, this is where information gets, where you have to really check things out, because you could see a surplus of X amount of dollars and then on a list, and then see that it was a lot lower, and you're wondering why. Well, here it is. It's a recalculation, of updated information. Time passes. They have, you know, every time they mail somebody, they're going to calculate another fee. Every time they have to make an adjustment or another entry to this document or docket or file, whether it be the clerk, the county, the attorney, whoever, the commissioner, there's going to be a fee involved in that process, or there could be a fee involved in that process. But here's where you can see also what it cost in the petitioner, which was the foreclosing entity up top. And then you also see down here their attorney fees. Now, this has reasonable attorney's fees. You might see this, or you're going to see this come up. Reasonable attorney fees. So now you have the answer to how much an attorney should cost in Georgia to file an actual case. Now, in this instance, they filed with the homeowner. So that tells you that most likely, well, actually it does not, but that's just an indicator of the fee, because anytime, unless you're taking an assignment, meaning you are taking claim, interest in full ownership of a claim, if you're doing a full assignment, then the attorney may be charging a little bit more for your agreement. But if you're not taking an assignment, they're always representing the owner. And then you have a side agreement because you're the finder who brought attention to the owner and connected the dots and notified them and got everything put together for them, found the attorney, followed the case, maybe even helped the attorney gather documents, or the homeowner gather documents and proof and supporting documents to put that case together. That's part of your service. You're doing the legwork to, well, if you're doing good service, to put that legwork in between so you can help this homeowner get their funds back. Okay. So, and then actually following the case, who knows how long it's going to take to get paid out. And a lot of times taxes and things like that, 60 days, 90 days, it's going to be the norm. You got to have an estate or something like that, or a probate, somebody passed away. That's usually always going to be more time involved, maybe 4 to 6 months on average. And if it gets hairy, you're probably looking at 6 months plus. But again, that just depends on what kind of case you have going on and what the details are. All right, so now you can see that was a large case. Okay, that was a lot of surplus. That was a lot of overage right there. But you can see this information of how it's broken down. Once you understand these key terms, it's really not that complicated. It's really just rinse and repeat, looking for those key terms over and over again, and just becoming a trained eye in this scenario. So just like I said before, they're going to extract fees out of whatever funds there are if they need to, because here you can see that these costs come out of the initial surplus, and there it is. And this is going to be what's um, claimed or paid to Mary, okay, because she made that claim. However means possible, because the attorney represented her. And now there's the county judge signature and things like that, and the date that the matter is closed. All right. And there you go. You need an attorney in Georgia who knows what they're doing. Bradley A. Hutchins, Canton County, Canton, Georgia. There's an email address. I can't read that. But if you probably Google search that and the address, and you can see that there's an attorney. That does not mean that the attorney is willing to work with third party services or finders or air finders and things like that. But that's just a way to find an attorney. And then all you got to do is reach out and ask them. And if you actually contacting that attorney, you could use this case and just to let them know, hey, I found your information on a case that I was researching. It looks like your paperwork is clean. Would you, be interested in cases that I have? And that's also where you want to present yourself as somebody who knows what they're looking at, right? That has done some legwork here and has reviewed a case and knows how to check. Why is that important? Because you don't want to just be throwing cases at an attorney and legal support, and there's nothing there, and then leaving it up to them to find it. Where they're going to start charging you up front to do it, or um, not just not paying attention to you. That's what it really boils down to. So finding an attorney is really one of those things that takes a little bit of skill, not really difficult, but it's just like anything else. Learn a little bit of what you're talking about. You don't have to know it all, but just make things make sense. All right. So that's what I just wanted to share today. Just a breakdown of one document and a tax deed, Cherokee County, state of Georgia. And remember, check out Bradley Hutchins. He's the one that filed this case. We'll catch you next time.